So, welcome to LiberalViewer First Wednesday live Q&A, the live question and answer show that I do on the first Wednesday of every month, answering viewer questions, both questions that people post before the show, which I always appreciate, so I can do a little bit of research, and then also questions that the live viewers who show up for the show every Wednesday at 4:30 p.m. Pacific time. I'm happy to answer those questions as well if I know the answer. I see that we do have a few viewers trying to see here. But before I get to the live questions, I did want to answer a few of the questions that people asked before the show started. Let me just do a quick check. I'm going to do a couple questions on the Establishment Clause, separation of church and state. Mainly I'm going to talk about the Supreme Court opinion that was decided earlier this week, the Town of Greece, New York versus Galloway case about prayers at a town council meeting. And before I get to the question about that, there's sort of a related question that one of my frequent commenters, not my most frequent commenter, but one of my frequent commenters who definitely has a point of view embedded in the question, asked me over on my LiberalViewer channel page. This is from Joel James, asked 5 days ago. Question for Wednesday. When America was founded on universal Christian morals with secularism to protect minority Christians, why is the ACLU trying to warp America into an atheist theocracy, or atheocracy, if you will? Well, as usual, I'll stay back on the... As usual, Joel James has put a bunch of false premises in this question, and I don't really want to go through each one of them. I mean, some of them are kind of blatant, but this whole thing about America was founded on universal Christian morals, I would argue that what the United States was founded on was the Enlightenment rational values of people like John Locke and English common law. And if you think that English common law has a Christian basis, I actually found a good argument against that from none other than Thomas Jefferson. I put a link down in the video description to his letter to Thomas Cooper, in which he debunks the argument that English common law, which is the basis of our constitutional law, was based on Christianity because this, as you can see in that part there, the system of law which was introduced by the Saxons on their settlement in England and altered from time to time by proper legislative authority from that time to the date of the Magna Carta. But then you can see this settlement took place about the middle of the 5th century, but Christianity was not introduced till the 7th century. The conversion of the first Christian king takes place in the year 598, and then 680. So hence there was a space of 200 years during which the common law was in existence and Christianity no part of it. So there is none other than American president and author of the Declaration of Independence, Thomas Jefferson, arguing that the United States is not based on Christianity, it's based on common law, and common law can't be based on Christianity because it comes from England before Christianity got to England. So I just thought, rather than going through all the false premises in that question, I would focus on just that one. And before I get to my next question here, which is also on separation of church and state, this is a question from NO8549, and I also got this earlier on Twitter, but here it is posted in the comment section of this video. What do you think about Supreme Court ruling on Greece, New York town meeting prayers? Well, that was a ruling that came down this last week. It's kind of a fractured ruling. Oh wait, that's the wrong one. I'm going to give you a couple of the quotes from the case in just a minute. But first, the majority opinion, the whole opinion is only joined by 3 justices. It's written by Kennedy, and it's joined by Alito and Chief Justice John Roberts. Thomas and Scalia do not join the whole opinion. and I'll get to that in just a minute. And then there is a dissenting opinion written by Elena Kagan. There's another dissenting opinion by Breyer, and then the Kagan opinion is joined by Ruth Bader Ginsburg and Sotomayor. It's good actually that Sotomayor is one of the dissenters, as I saw someone point out this week. If Sotomayor hadn't been in the dissent and had been 6-3 with Sotomayor in the majority, it would have been the 6 Christians versus the 3 Jews, which wouldn't have been really a good appearance for a split in the Supreme Court on a religion case, especially because one of the main issues in the case was whether it was a sectarian prayer. That's one of the reasons that this was kind of controversial. I actually, this is about a town in New York that had a prayer before the town meeting began, and they let people, almost all the prayers were Christian. They used like a local directory of houses of worship to decide where the prayers would come from, and they got almost exclusively Christian prayers. And here over, I'm going to do a quick Marco Rubio drinking water. As you can see, these are a couple excerpts from a couple of the prayers. And they weren't just these generic prayers to like a generic God. They were, you can see I've highlighted that they even specifically mentioned Jesus in the prayers. And that's a little different than some of the prayers that, I mean, generally in the lower court rulings have said that if it's a non-sectarian prayer, then it's not going to violate the Establishment Clause. And the one part of Kennedy's opinion that was not joined by 2 of the conservative justices was what's called the coercion test, because there's actually a part of Supreme Court constitutional law that says that if you're coercing people into religious observance or even making them feel uncomfortable by having religion in a government setting, then that is unconstitutional establishment of religion, or a law respecting an establishment of a religion, as I'll get to in a minute. And so Kennedy, in part 2B of his opinion, still believes in the coercion test, and that was the part that Thomas and Scalia wouldn't join because they apparently don't believe in the coercion test. But first, here is that like the key part of that Kennedy opinion. It says here, this case can be distinguished from the conclusion and holding of Lee versus Wiseman. That said that a school prayer at graduation was coercive, and he's basically saying that it can be distinguished because at a graduation, the people have to be there. But nothing in the record suggests that at this town council prayer meeting, the public was dissuaded from leaving the meeting room during the prayer, or arriving late, or even, as happened here, making a later protest. And there's nothing, should non-believers choose to exit the room during a prayer they find distasteful, their absence will not stand out as disrespectful or even noteworthy. And should they remain, their quiet acquiescence will not, in light of our traditions, be interpreted as agreement with the words or ideas expressed. And it's not an unconstitutional imposition on a mature adult. So Kennedy is distinguishing this prayer at the town council meeting from the prayer at a graduation, where people have to be there, and if they leave, they're going to miss their graduation, and it's a lot more coercive than at the beginning of a town council meeting when the business hasn't even started, which is one of the other points he makes. But Thomas and Scalia would not join that part of the opinion. In fact, Thomas said that he doesn't even think the Establishment Clause applies to the states. It only applies to Congress, and that's like totally against Supreme Court precedents from the past, where, I mean, at the time the Bill of Rights was passed in 1791 and all the way up to the Civil War, nothing in the Bill of Rights applied to the states. There was actually a Supreme Court opinion, Barron versus Baltimore, where people tried to get one of the provisions of the Bill of Rights, I think it was the Takings Clause from the Fifth Amendment, to apply to the states, to a state taking, and the Supreme Court said no, the Bill of Rights only stops the federal government from imposing on people's rights. The state governments, that's up to the people, the people of the state, because they thought the people of the state were closer to their state governments, and so the federal government didn't have a role, and they, the whole slavery thing turned out to make that wrong, and that's why there was the Civil War, and then the 14th Amendment was passed, which has a part of it that says that no state shall deprive any person of life, liberty, or property without due process of law, and the Supreme Court's used that to impose most of the restrictions of the Bill of Rights that restrict the federal government on the state governments, and that includes the Establishment Clause that says that Congress shall make no law establishing, Congress shall make no law respecting an establishment of religion, and that's actually a broader phrase, and I discussed this in greater depth in a video of mine. Is National Prayer Day constitutional? And I put a link down in the video description. You can watch the whole thing, but here is a 1-minute clip from that video explaining kind of what I'm talking about the broader meaning of the Establishment Clause and what James Madison thought about it. And I'll show that before I get to the Thomas dissent in just a minute. The meaning of the Establishment Clause, because that clause does not just say the Congress shall make no law establishing a religion, though in fact at least 3 of the versions of the First Amendment rejected during the House and Senate debates in 1789 did include that phrase, but the final version, eventually ratified, includes the much broader prohibition that Congress shall make no law respecting an establishment of religion, and no less an authority than James Madison, who proposed the original draft of the amendment, said these words mean that, quote, the Constitution of the United States forbids everything like an establishment of a national religion, unquote. And in the same document in which Madison revealed that real meaning, he also specifically mentioned problems with government prayers, writing, quote, religious proclamations by the executive recommending thanksgivings and fasts are shoots from the same root with the legislative acts reviewed. Although recommendations only, they imply a religious agency making no part of the trust delegated to political rulers, unquote. So yeah, that is my belief about what the Establishment Clause means based on what Madison wrote, and that especially in his detached memoranda, which is linked in the video description of that is National Prayer Day constitutional video. But Clarence Thomas actually said that he doesn't think that the Establishment Clause applies to the states at all. They can do anything they want in terms of establishing religions, and he's not even positive that it would stop the establishment of a national federal, U.S. religion. I want to show you, this is my favorite sentence from the Thomas dissent, and Justice Scalia joined this dissent. He said, as an initial matter, the clause, this is the Establishment Clause, probably prohibits Congress from establishing a national religion. You see the word probably there? That is one of the most ridiculous parts of Thomas's dissent there. But then he goes into this long thing that because there were some states that had state religions, but like I think Virginia may have had a state religion at the time that the First Amendment was passed, that that means that there can be state religions today, and he forgets that whole history I was just talking about how none of the provisions of the Bill of Rights applied to the states at all until after the Civil War, and I mean, I don't know why. I mean, Clarence Thomas is such an outlier on the Supreme Court, and I guess, well, Scalia joined his dissent, although Scalia also joined Alito's dissent, and that, I read a bunch of commentary about this Supreme Court opinion, and I hadn't seen one thing that when I actually read all the opinions, I read the Kennedy opinion, and then I read the Breyer dissent, and I read the Kagan dissent, and I read the concurrence from Thomas. Did I call Thomas a dissent? I hope I didn't call it a dissent before, because Thomas was a concurrence. The only thing he didn't join was that part 2B, and then I also read the Alito concurrence, and from the one thing I hadn't heard from any of the analysis that I got from reading the Alito concurrence is I don't think Justice Samuel Alito really likes Justice Elena Kagan, and I get that from this opinion. First, here's like the first line of Justice Alito, with whom Scalia joined both the Alito concurrence and the Thomas concurrence, and he says, I write separately to respond to the principal dissent, and the principal dissent is Kagan, which really consists of two very but intertwined opinions, one quite narrow, the other is sweeping. I will address both. So the whole reason that Alito wrote his opinion is because he wants to attack what the principal dissent wrote, Elena Kagan. And I'm not going to show all the things that he talked about. He did say one thing I kind of agree with, although he went a little bit too far. He said, the principal dissent claims to accept the court decision in Marsh versus Chambers. And, I mean, that's why I don't even agree with the dissent in this case. And if you remember, if I go all the way back to NO8549's original question, what do I think about the Supreme Court ruling? I think it's actually been blown out of proportion somewhat. You know, people say it's like the end of the Establishment Clause, because this opinion isn't really so bad when you consider the Marsh versus Chambers decision from 1983, and I put a link down in the video description to that decision. And that was a decision by the Supreme Court back in 1983 that said that the prayer that the Nebraska legislature started its session with, that was constitutional. And I never agreed with that. And so once you accept, though, that Marsh versus Chambers is good law, that a legislature can start its session with a prayer, it's not very far to get to this Town of Greece decision. You know, the dissent were trying to distinguish from Marsh versus Chambers, and by saying that that's like, that no one's really, well, here it is, I'll show you. And this is the one part of Alito's concurrence I actually agree with. He says, the principal dissent claims to accept Marsh versus Chambers, which upheld the constitutionality of Nebraska's legislative practice of prayer at the beginning of legislative sessions, but the principal dissent's acceptance of Marsh appears to be predicated on the view that the prayer at issue in the case was little more than a formality to which legislators paid scant attention, and it describes the scene: a session of the state legislature begins with or without most members present, a non-sectarian prayer, you know, not mentioning Jesus, right? And some legislators are seated, and a few people are exposed to the experience. And this sort of perfunctory and hidden away prayer is what Elena Kagan implies is what Marsh and the First Amendment can tolerate. And that is kind of what some of the lower courts have said, have tried to narrow Marsh versus Chambers. But if you really believe in the Establishment Clause, I don't see how you can agree with Marsh versus Chambers at all, that starting the Nebraska legislative session with a prayer to God, even if it's a non-sectarian prayer to God, I mean, that's where there's a violation of the Establishment Clause, and this is just like an incremental extension of Marsh versus Chambers. So I think this decision has been kind of blown out of proportion because it's not that much more than what already existed under Marsh versus Chambers. And hold on, I'm going to take a quick sip of water here. And I'll show you why I really think that Justice Alito doesn't like Justice Kagan. Here's the end of his concurrence about his final point. I'm troubled the message that some readers may take from the principal dissent's rhetoric and its highly imaginative hypotheticals. For example, the principal dissent conjures up the image of a litigant awaiting trial who is asked by the presiding judge to rise for a Christian prayer, of an official at a polling place who conveys the expectation that citizens wishing to vote make the sign of the cross before casting their ballots, of an immigrant seeking naturalization who's asked to recite a Christian prayer. Although I do not suggest the implication is intentional, I am concerned that at least some readers will take these hypotheticals as a warning that this is where today's decisions leads, to a country in which religious minorities are denied the equal benefits of citizenship. Nothing could be further from the truth. All the court does today is allow a town to follow a practice that we've had previously held permissible for Congress and state legislatures. It's seeming to suggest otherwise. The principal dissent goes far astray. And if you read the whole Alito concurrence, I think you'll definitely agree with me that Justice Alito is not very fond of Justice Kagan, or at least that's how I would read his tone in his concurrence there, which is almost entirely directed at Justice Kagan, which is something I hadn't really seen in any of the commentary about this decision that I read. And it's a very splintered decision. Like I said, there's part of the so-called majority opinion that only gets 3 votes. And then Thomas and Scalia go off on their own and say They don't believe in the coercion test, and they think that maybe states can't even violate the Establishment Clause, only the federal government. And anyway, and like I said, it was almost a split between the Jews and the Christians on the court, which would have been kind of interesting. But anyway, those are my thoughts on the Supreme Court opinion in Town of Greece versus Galloway that came out this week. I hope that I didn't rant or go off too much on tangents there, and that was kind of understandable. But I'm going to take a few more questions that are two more questions that people asked beforehand, and then get to some of the live questions before I finish up the show. I had a question asked by Bob Wilson yesterday, asking me about what do you think about the problem of our first past the post voting system. And I'll let you, while I take a quick drink of water, sort of scan through that. And this is basically about having a different voting system where people can decide that they can vote for like their first choice and their second choice. And I think I have a couple thoughts about that. First, I think that there are some people on the left who have sort of this misconception that the reason that some of the more extreme left-wing ideas, and I don't know if people on, I don't hang out with extreme or people more extreme on the right, but in some of my activism on the left, I do talk to people who are much more left than I am. And I think one misconception that some people who have those opinions have is that there's a problem with the voting and not the voters. I think if there was a different voting system, their ideas would have more chance of passage, when the problem is there just aren't enough voters to get together, you know, a majority. Even if you have like second place voting, or, you know, you can vote for your first, second, and third choice, or I'm not exactly sure what Bob Wilson was asking in terms of what form of different voting he wants to institute. But I think that sometimes people think that if they change the voting system, their ideas would be enacted, when no matter how you switch around the voting system, it's just those ideas aren't that popular. They may be good ideas, but they're just not very popular ideas. And I think also one of the problems with voting systems that lets more fringe people get some sort of representation is that it sort of splinters consensus. You know, I talked about that in some previous videos about how the way like Hitler came to power in Weimar Germany was that they had this parliamentary system. And, you know, I know a lot of my European viewers, you live in parliamentary systems, and of course Canada, but I think parliamentary systems are different from the system in the United States that gears us more towards centrists by not giving as much representation to the splinter groups. And I mean, that has its downside that, you know, more innovative, progressive ideas may not be able to be implemented as quickly. But it also has the upside that the United States has not veered as far to the right as fascism, as far to the left towards communism that Europe has. And there are other reasons for that, but I think that's one of them, because our whole constitutional system pushes people towards the center, even though our center has been moving towards the right over the past couple decades at least. I think a lot of people would agree. But anyway, then the final thing I want to say about the change in voting is I actually am always hesitant to talk about these new sorts of voting systems, because, you know, they're almost like game theory or something, or like even these war games I used to play when I was a kid, is that, you know, you can try to game them out and figure out what's going to happen, but until you actually institute them, you never really know how they're going to affect what happens. And, you know, you can try to hypothesize and theorize, but that's what I really want to see. And he talked about an Oregon initiative. I wouldn't mind seeing some of these things implemented and then seeing what effect they actually have, because I'm not sure you can really analyze them prospectively before they're instituted, because there are too many complicated pieces, and you never know how things are going to turn out until you try them. So, I mean, I'm not against trying them, but I'm kind of skeptical about how useful they really are in getting more leftist ideas, if even that's what the person is looking for, or getting more progressive ideas instituted, because I'm not sure that's actually what they're going to result in. And then the final question asked before I started that I want to address is from Terry Alther here. He asked a question for First Wednesday. And you can see there are a couple links in there. And basically it's about whether Supreme Court justices should have more... sorry, I'm taking a quick drink of water here. Should have any sort of stronger ethics requirements placed on them. You know, there's been a couple questions about whether Elena Kagan, who used to be in the executive branch and worked on, in the Obama administration in the Solicitor General's office, unless I think I have that right. Elena Kagan was in the Solicitor General's office, and if she should recuse herself from like Obamacare and some other things that were worked on legally when she was there, and then people said that Clarence Thomas should recuse himself because his wife talked to these Tea Party groups and got all this money, or worked for these Tea Party groups and was paid all this money, and especially Tea Party groups that opposed Obamacare, so he should recuse himself from the Obamacare cases. And so Terry Alther asked me about that and what I think about it, and if it jeopardizes Supreme Court rulings. And I actually, I have two reasons why I don't think it's that big a deal. First, I think there's a real separation of powers problem. In fact, if you follow one of the links in the question that Terry Alther posted there, this is like one of the last paragraphs, says could set off an epic separation of powers battle between the two branches of government, because Congress doesn't really have the power to tell the Supreme Court what to do. I mean, they have lifetime appointments specifically so they don't get interference from politicians and political pressures. And I mean, Congress does have a power against Supreme Court justices if they don't like what, if they really think that they are out of control, and they can impeach them. But beyond that, I don't think they can put on all these regulations. And it's true that lower judges do have these codes of ethics they have to follow, but the reason is because there are higher judges to enforce it on the lower judges. There are no higher judges to enforce the ethics rules on the Supreme Court. And I actually don't really buy the premise, like especially like the Clarence Thomas issue. Does anyone really think that the reason Clarence Thomas voted against Obamacare is because his wife Ginny got money from Tea Party groups? No. I mean, maybe the reason he's with his wife Ginny is because they both have these like far right-wing views, but I don't really think that what Clarence Thomas writes on the Supreme Court is influenced at all by money that his wife Ginny gets. I think his right-wing wacko opinions are all his own, and are going to be all his own for however long he's on the Supreme Court, which could be for a long time, you know. That's one thing I wanted to mention when I was looking at the fracture in that town of Greece, separation of church and state opinion, is Clarence Thomas is pretty young for a non-Obama appointee. I think he was born in like 1948, so he's in his 60s. He could still be on the court for a while. The two, Ruth Bader Ginsburg is a really old, I think she may be the oldest justice, which if she doesn't retire while Obama's president, that's a good reason to vote for Hillary Clinton if she's the nominee, even if you don't like her for anything else. It's just so the Republicans don't replace Ginsburg with someone who will make the balance even worse. And then there are two justices who were born in 1938, I believe. Was it 36 or 38? I looked it up before the show. But so they're in like their mid-70s. That's Scalia. And wouldn't it be nice if we had a Democratic president to replace Scalia? And Kennedy, who just wrote that opinion, he's like the swing vote. They're both in their mid-70s, so the next president may well appoint. I mean, you never know with Supreme Court justices, but they're Ginsburg, Scalia, and Kennedy, I believe, are the three oldest on the court. And I'd hate to have Ginsburg replaced with someone conservative, and I'd love to have Kennedy or especially Scalia replaced with someone more on the left, although that could be difficult with the whole Senate and well, who knows what will happen. But anyway, those are the questions I wanted to answer before the show started. And I see I'm almost at, or I'm over 30 minutes already, but I also noticed that I have about 20 people who showed up for the live show, so I want to see if I can look at a couple of live... Oh, there were a couple of questions posted before the show I didn't have time to take out. I see Real Killa, which is asked me sort of this question having to do with the word snen. I think it's just a way to get me to say that word, which I've said, so I think I've already answered that question sufficiently. 7 asked me about this thing about planes controlling the weather, why there's not more coverage of that. I looked in, as far as I could find, it seemed more like a conspiracy theory than the truth. Let's see. Christopher Chavez said, I commented over 2 months ago on LiberalViewer. The article I referred to is at NBC News to /. Could you elaborate more on this without regard to government takeover? I don't know. That would take... I have to look at that. Sorry, I can't understand what that question's about. Pat's Rules 213 says, what would be the LV plan on the over decade-long war in Afghanistan? Well, I've made a couple of videos about that over the years. One was at the beginning of the Obama administration called Who Lost Afghanistan? And it's about how the Bush administration kind of lost the war in Afghanistan before Obama came along by supporting these corrupt warlords instead of really supporting the people of Afghanistan, and supporting Hamid Karzai, who ended up being really corrupt, and the people had faith in and then lost faith in. And it's, I don't know exactly what we can do at this point. I mean, at this point, it's more about cutting our losses than really helping Afghanistan. I'm sorry to say. I don't know if it's too late, but I do see... I mean, I think the United States has some responsibility to try to build up the real democratic and liberal forces in Afghanistan such that they are. And I think they still exist to some extent, and I talked about those in my video, Who Lost Afghanistan, and I would recommend that you go watch that video if you want. Even though it's a few years old, I still think I stick by what I said in there. Let me scroll up here a little more. These are all people asking questions before I even showed up. I'm sorry I was late. One of the reasons I was late is that YouTube, I have to like preview and then start the stream, and YouTube made me wait like several minutes before it would let me start the stream. And so anyway, I think that I'm over half an hour here, and now I'm gonna finish up the show. But one more thing I wanted to say is that I have a video that is almost complete, and it's on a separation of church and state issue. It's on the Mount Soledad cross, and I actually have had it all, like the whole audio, done before the Supreme Court decision, so it doesn't refer to it, even though I don't think it's really affected by the Supreme Court decision, because the Supreme Court decision is really specific to legislative prayers, and this is about the Mount Soledad cross, which is sitting outside of San Diego. It's this huge, like 500-foot cross that's been found unconstitutional a couple times. Anyway, the video I have should be available tomorrow sometime, probably in the morning. It's called Fox News: Huge Christian Cross is Not Religious Endorsement ? So look for that. And of course, join me every Sunday for LiberalViewer Sunday Live Clip Roundup, where I take the best clips from the Sunday morning news shows and the quasi-news comedy shows over the weekend to show you what's going on in the corporate media. That's at 6:30 p.m. every Sunday. I hope you enjoyed my answers to your questions today, and I guess I'll be seeing you all around the internet.